Welcome, everybody, to the Bold Inventor Show. I'm JD Hoovener, your host, patent attorney and founder here at Bold Patents Law Firm. Today, we're talking about Olympics. We have copyright law. Copyright. Now, there's a lot to do with copyright here in the Olympic Games. I mean, think of anything that is creative. One of the first, the biggest, probably the most well-known item of the Olympic Games is that torch, right? The Olympic torch. It's a symbol of the games, right? It's this sort of iconic, passing of the torch. And there was this entire run. I think it was 68 days before the Olympics started. And you've got all kinds of celebrities. And I think for me, I don't know, one of the most interesting facts is how much Snoop Dogg was featured, okay, among all of those celebrities. But there were a lot of, famous, faces, right? Personas. And so it's kind of part of copyright, maybe even privacy law. You've got this protection over celebrities, right? Individuals, your human face, and whether or not that can be commercialized or sold, right, without your permission. And so it's kind of a unique area of copyright law, perhaps privacy law, where it's, aside from that, more traditional copyright law, you've got broadcasting rights, okay, the ability for the images, the videos, all that, from the Olympic Committee. Streaming, live streaming, there's tons to do with all those contracts, the different networks involved. Okay, so a lot of that media, everything having to do with capturing live or pre-recorded edits, right? All the work that goes into it. Music is really interesting. So you've got lots of different points where music can come into the Olympics. Okay, we saw the live performances, right? Lady Gaga, I think for me, was one of the most impactful. There's a ton of different artists that perform live. And with music, I mean, it's such an involved area within copyright law. There's, of course, the actual sheet music that's written, okay? There's the lyrics, the words that are said or sung, and then the composition of music involving different instruments, each piece perhaps having its own copyright, and then the collective work having another copyright. And so that means that any reproduction of any of those I just mentioned without the permission of the underlying rights holder would be an infringement. Okay? So there's tons of intellectual property with music, and then you can even go more to the electronic side on the broadcast itself. You've got different sounds and music playing in and out as they transition from sport to sport. It's different things there on copyright. Nothing particularly stands out in terms of events that happened or things that are newsworthy. But let's go through the next list, just to cap on copyright law. One thing you can do is that you can register, where you can actually get, as an artist, maybe you can get representation from an attorney to help you, but you go to the Library of Congress and you can get that work registered. And one main reason for doing that is if you've really put a lot of effort into it, and I also say if you're planning to commercialize it, okay, whether it's a piece of art, a music, right? Maybe it's a dance you recorded, but that's one of the main criteria to having a copyright is that it has to be fixed in a tangible means. That's the legal term, but really you have to have the ability for you to capture it, whether that's paint captured in a canvas or if it's a song captured on a recording. Okay, so that means it's tangible. It's got a beginning and an end, has four corners of the paper. That way it's a distinct, not movable, specific piece of art, and that can be recorded. And one of the big benefits of getting it recorded with the Copyright Office, the Library of Congress, is you can then bring that forward to federal court if there is a potential infringer. And in most cases, if there is a registration, then there'll be a prima facie case that you're the owner. Okay, and so there won't be any real question as to who created it, when it was created, what it is, because it's all documented there before court. So let's talk about trademarks. And my gosh, when you think about all the different brands and logos and anything having to do with business, this is a federal right. When a company wants to protect a word mark, right, bold, English letters, or a design mark, right, where it's actually a picture, and it's made up of different colors or shapes, and it is all about how that word or that shape or the design is associated to a product or service. And it's all about making sure the customer is not confused and they can attribute that good or service to where it came from, right? Source recognizing. So I think without I have to mention, sort of the iconic Olympic rings. Okay, we can all picture those rings, right? And I actually went to the IOC website, and they've got a very specific, definition of the Olympic rings, which I thought was pretty cool. And I'm not sure if it's, part of what's in, the trademark application. Matt would be able to share a bit more, but I'll just share my screen here real briefly, just so you can read it off. The Olympic symbol consists of 5 interlaced rings with equal dimensions, used alone in 1 of 5 different colors. Oh, they got the U in there. Okay, kind of the European or UK spelling. When used in its 5-color version, these colors shall be from left to right: blue, yellow, black, green, and red. The rings are interlaced from left to right. The blue and black and red rings are situated at the top. Yellow and green rings at the bottom, in accordance with the following graphic reproduction. So the words really describe it quite well. It's pretty cool that this is serious business, and use of those rings without permission of the IOC, you're going to get in big trouble. So that's definitely a trademark. It's a distinction of the business that the International Olympic Committee, the Olympics themselves, they each get to have as their own. So that's where we'll start with trademarks. But thinking about the athletes and all the different countries and how they might or might not be advertising or promoting different businesses, I didn't see a lot of that. There wasn't. Maybe that's one of the rules. I think it's a good rule to have. You don't see sponsors, or like you might see at a local or even a regional track meet, where athletes are sponsored with different brands. You see it for sure with like race cars, right? In different sports or athletics. And this was really clean, right? You don't really see much to do with a lot of advertising. And correct me if I'm wrong, if anybody else is online and saw any of that. But that's typically where trademarks would come in. Is you've got a recognizable, or you want to try to promote or get some awareness with that. Of course, where you do see it is on the commercials, right? In between the broadcasts, which are paid for, spots for companies to advertise. Their slogans, their trademarks, their branding is going to be definitely mentioned. Okay, let's talk patents. There's 3 main categories that I was able to kind of break it into. You've got merchandise, okay? Lots of different things, like you can imagine cups and ties and hats. And there's going to be a lot of unique, sometimes high-tech, sometimes even really low-tech designs. And some of these apparel, usually if it's kind of a one-off event, you're probably not going to invest a utility patent toward it, but certainly a design patent to make sure that the specific merchandise, if it has a unique shape to it, then it's going to be protected under design patent. And if they're going to be selling it overseas, it may make sense for them to file something in a foreign country, where there's a big enough market for it. Certainly France would be a good idea to have gotten. Uniforms, there's a lot here. There's actually a separate article where I found this Lycra, L-Y-C-R-A, Lycra company. There's one of the teams, the Brazilian volleyball team, they had their jerseys for the summer games feature with the trademark Cool Max eco-made fiber, and it's basically a recycled textile waste. So it's very eco-friendly. It's Brazil's sort of commitment to sustainability, and they're bright. They didn't necessarily inhibit or benefit necessarily, and as compared to any other athletic garment, but knowing that they're sustainable and just as effective in wicking sweat or whatever they're looking for with that sort of sport. That's a patented type of article. Nike made the news. They had a couple, probably the most talked about, I guess you say controversial sport was the first time it is the Olympic Games. This was the breakdancing, of course. And I think maybe if you've seen it, the Australian breakdancer, it's one of those things that I might be able to have done that, some of those moves. So Nike created their own shoe. This is their to support breaking, which is the first time it was being at the competition for the Olympics. And so they have their Nike Jam, and it was designed for breakdancing. And it's got all these different features here, and I was able to track down the patent here. I thought I'd share that a little bit. So this is patent granted just in time, April 2024. Sole structures having multiple hardness or flex promoting structures, and tons of inventors out of Portland, Oregon, which is the headquarters in Beaverton area at Nike. And the abstract here reads that it basically has two major surfaces, right? There's this bottom surface and a harder second surface. And it's got this sort of really bumpy ridges here to give additional support when the foot is, at an angle or upside down, when you need to have your center of gravity is going to be moving a lot. And so this is a utility patent, which I think is relatively uncommon for footwear and can be challenging, right? Because you're trying to provide the fact that you've got a new shoe. There's been millions of shoes developed. You've got to prove that it's novel and non-obvious. Nike has done that. More typical, you'll see the design patent protecting just the shape of the shoe, the outer appearance. But this does protect the functionality of the shoe. And I thought the claim was really well written. For some of those patent attorneys out there, we'll show how Nike's writing their patents these days. So really just two major parts of the claim. The first independent claim, article of footwear comprising an outsole component. Okay, so that's the first major piece, an outsole component. And within that outsole component, it's got a first material having a hardness, and then the second material, like I was saying. And I haven't actually heard of what's called a short A hardness, but the second material's got to have at least 15 short A hardness points higher. So it really could be anywhere above that. And so it has this sort of flexibility where the bottom layer is going to be more flexible, I assume, than the underlying layer. And then there's a specific point that has to actually extend down and touch the ground. So the inner layer has to, at some point, contact the ground or have the ability to contact the ground. And then the second major element is a slit through the outsole, extending to the lateral perimeter. So basically on the edge of the sole, there's a slit, and it has to be, the slit has to be less than 25 millimeters. So the slit can't go beyond that. If it's anything 25 or less, then it's going to be infringing. So I think Nike must have assumed anything bigger than 25, it's going to be so floppy, that slit's going to be more of a hindrance than a help. So there's a nice tidy claim. So that's on the Nike shoe. It's called the GM. I'll show it one more time here. Nike GM. I'm gonna spend too much longer on the technology products, but one more on Nike since I was cruising their website. The glasses, right? The smart glasses is not new, but they can do all sorts of different things. Including giving data to runners, provide information about where they're going to be going. And I don't know if I've read much about whether they can wear these during live competition. If there's any restrictions as to any smart glasses being worn during competition, that would be pretty interesting. And so here's what's called the Nike Athena and Nike Zeus sunglasses. Those are pretty awesome. I think those in terms of naming. So they've likely already pursued trademark protection for some of those names. The Greek god and goddess, as you probably recognize. Pretty striking. I don't know about you, but those would be quite the fashion statement to bust out. So patents, yes, certainly technology, sports equipment, apparel we talked about. Maybe the only other thing I didn't talk about was, the AI, tons of AI, behind the scenes with respect to, and I think Intel and Samsung, those main engines there, providing, the partnership. That's what I was reading in the article, that they have, computer vision, training to build align athletes with the appropriate sports, innovators enhancing the accessibility through AI-generated 3D models, navigating the voice assistants on smartphones, and they can do 8K streaming. And I'm not all that informed with respect to how much they can do or how much actually got transferred. But if anybody watched in 8K, let me know, and I wonder what the difference actually might be. All right, last one, don't forget it, is trade secrets. For those that don't know about trade secrets, you don't actually get a registration or a certificate for it. This is kept confidential within your company. And there's some stuff within the Olympics that I think this article made mention of, where there's know-how, right? Information within your company that helps you make money, right? That is economically viable. and you're actively keeping it secret. You're not just sharing it with everyone, certainly not sharing with the public. It could be processes and strategies for getting local communities, organizations put together, right? Just simply who and how and what that conversation looks like. Maybe you're financially incentivizing how you're pulling together a community for an event like the Olympics. IOC probably keeps that pretty close to the chest. Certainly sponsorship agreements and marketing strategies. Okay, those are really good examples for trade secrets, ways in which you conduct business. And so oftentimes to protect those, it is recommended for those individuals and companies to document the top, say proprietary, say trade secret, and don't give access to all of your employees and staff. That way it's going to be very evident that you're keeping it secret and you've got safeguards that are up to speed technologically to keep its confidentiality.